Okay, I opened the door, let everybody into the webinar. Hopefully you can all see and hear me. Welcome to our Special Kids, Special Trusts webinar by Solomon, Steiner, and Peck. My name is Laurie Steiner. I'm a certified elder law attorney with the firm. Now, if I say elder law attorney, that sounds like, how could I know anything about special needs children? But actually part of the specialty to be certified in elder law is to have experience and to have knowledge about disability planning as well, because special kids can be young children, it can be older children, it can be anybody who happens to have a disability. So I'm kind of focusing the name as though for parents who are worried about their children, whether they're actually minor children or whether they are adult children that have disabilities of one type or another, physical and mental. So I was tested about that and I passed my certification, so I know something about that. I think we have most people in. I'm going to keep watching for participants to join and let them in as they get into the waiting room. But in the meantime, we're going to get started. If you have a question during the presentation, down on the bottom of your screen there should be a little chat box. It says chat, and if you open that up you can type in a question. It won't be seen by everybody, it'll just be seen by me, so you don't have to worry if you think it's a stupid question. And I will try to answer those as they pop up, and then leave a couple minutes at the end in case there's any additional questions people want to ask. So with that, we can kind of get started here. So there we go. So if you want to read later, because you'll get a copy of this PowerPoint outline after the fact, that's my bio. You know, want to see that, read it before bed sometime when you're trying to fall asleep. All right, so we're going to talk about benefits first, what possible benefits can be obtained by a disabled child or person. There's both Social Security benefits and there are Medicaid benefits for health insurance primarily, because most people with disabilities, that's a big part of the issue. You need to have health insurance to cover the issues that are going on. So I'm going to start first with Social Security disability rules. Going into this, you have to understand that there are two types of Social Security disability payments that you can get. One is actually Social Security disability income, and Social Security disability income is available to people who have a work history. So they have to have enough quarters in, usually 10 years basically, of work, and they have to become disabled and apply within 5 years of ending work. And the Social Security disability income is sort of like what you're racking up as you're working, and you're just getting your Social Security early because you're disabled at that point. That has no income rule, it has no asset rules. You can have $1 million and get Social Security disability income as long as you don't have income coming in. If your income goes up over a certain level, if you're still able to sort of work but not work full time, as long as you've got less than about $1,200 a month in income coming in, you can continue to receive Social Security disability income. But many disabled folks don't fall into that category unless perhaps they had a disability that happened later in life. People who have never worked because maybe they were born with a disability or it happened early on in life can try to get Social Security benefits, which are called SSI, Supplemental Security Income. And Supplemental Security Income, you don't have to have a work record. In fact, you wouldn't be getting that if you had a work record that you qualified for the other kind of Social Security disability benefits. And you have a limit on assets and a limit on your income. So you can't be earning a lot of money, otherwise you'll lose the disability, and you can't have a whole lot of assets. So I'm focusing my discussion mostly on the SSI benefits, the Supplemental Security Income for disabled people, because it's much harder to qualify for, and it kind of goes along with the Medicaid rules that we talk about. with Social Security disability income, where you used to work and you can't work anymore. Once you've been on disability for 24 months, you can get Medicare early, even if you're not 65 yet. So that helps cover the health insurance issues. And hopefully you've got some other insurance, maybe left over from work or something, that tied you through that 2 years. So you can get Medicare, then you get your supplement, then you've got your prescription plan, and you may or may not need Medicaid ever. However, if you're trying to qualify for and receive SSI, supplemental security income, that you have no assets, you have very little income. And that immediately qualifies you for Medicaid, because the rules for qualification for the SSI benefits fit the qualification rules for Medicaid, at least in the state of Ohio, they do. So that's a little bit of background about different ways that people get Social Security disability, but I'm going to focus now mostly on the SSI, Supplemental Security Income, which many disabled folks are able to receive. There is asset eligibility. You can't have more than $2,000 basically in the bank. Now you might get a disability check. And that puts you over the $2,000 limit for the month of receipt. However, when you then spend that money for the month on what you need to keep going, your assets have to fall back below $2,000 by the end of the month, so that going into the next month, you're below $2,000 and you get your income and you start that monthly cycle over again. There's also income eligibility. Of course, if you had income because you could work, you wouldn't be getting these Social Security benefits. The problem with asset eligibility and income eligibility for a minor trying to get SSI because of disability, potentially from birth, is they deem the parent's assets as available to the minor disabled individual, and therefore there's a lot of children who can't qualify for SSI until they are 18 and an adult, and that deeming of assets and deeming of income isn't, from their parents to them, isn't a part of the calculation anymore. There are some benefits that potentially you can get on the health side and caregiving side with the Department of DD in the county in which you live. Those are different kinds of programs through DD, the DD board, that kind of override some of the rules if there's somebody profoundly disabled and still a minor and can't collect some of these other benefits because of deeming rules. So that's a whole nother discussion. When there's a disabled person trying to qualify for SSI, there's certain assets that are exempt. Kind of, you really got to have these things, so they're going to let you have these things aside from the $2,000 in the bank. For example, you can have a house. So a disabled individual, even getting SSI, is allowed to live in a house and own that house. They can have a car. You can have a prepaid funeral contract, which is hard to think about if it's a child you're dealing with about getting SSI, or even an 18-year-old as they become an adult. But a prepaid irrevocable funeral and the cemetery plot is exempt. So if you got a little bit of money in, maybe from a gift from a well-meaning grandparent, and this child is needing to get benefits, just hit age 18, maybe got a present from a birthday present, and they're trying to get rid of that money to be able to qualify for SSI, you can spend on a house or car or funeral, and that will not cause any kind of eligibility issues as long as the bank account stays down below $2,000, or any other assets that are liquid, like money in a bank account. You can also keep your clothes, you can keep your stuff, so you can have a life, but the SSI intends it to be for very low asset, very low income individuals who don't have that work record. Okay, so I talked about what if this beneficiary, this disabled individual, comes into some money. We have disabled individuals come into money from well-meaning relatives, from a car accident, from maybe it was a medical malpractice issue that caused a disability for somebody, and now they won and they have this extra money. You can only go so far in taking care of a house, a car, and a funeral. So one thought that comes up is, well, you know what? I've got all this money. I'm just going to give it away. I'm going to give it to my parents. I'm going to give it to siblings, or put it put it away someplace so that Social Security can't see it, so I can get those SSI benefits. Unfortunately, for SSI eligibility, they know people try to do that. It's an old trick. It's not a new trick in the book. So SSI has a rule that says if you've given away any of your money within 3 years of applying for SSI benefits, they will see that. They will ask about any benefits, any assets given away in the last 3 years, and they will penalize you by not giving you that SSI benefit for a period of time. So how they figure out how long you would be punished by having these number of months that you can't get benefits, they take the value of your gift. Let's say it was a $50,000 gift, and they say, okay, you gave away $50,000. We think you did that to qualify for SSI, so we're going to disqualify you from SSI for a number of months, determined by taking that $50,000 divided by the current benefit amount, $783. So you would be ineligible for SSI for about almost a little over 5 years. But if you had waited until you gave it away and wait 3 years before applying for SSI, they won't see that gift, and there won't be any ineligibility time during which they don't pay benefits. So think twice before giving away money, or a disabled person they're giving away their money, so that we can make sure it doesn't run afoul of the rules. For Social Security disability income, right, the kind where you worked but you can't work anymore, they don't count your assets. So basically, if you have to give away some assets for that, you don't really have to, but if you chose to, they're not looking at asset eligibility. They're only looking at whether or not you have the ability to work and continue working and get some kind of income. It doesn't have to be the same job you had before. They really look at, can you do any job? And most people lose the first several rounds of trying to get Social Security disability income. And for SSI, it's about the same thing. They don't want to pay out the benefits. You've got to prove everything on paper, and the application process can be pretty awful. You start that online. There you go to the Social Security website, and there is a place to make those applications. If you're going to do that for somebody, go on first and take a look at the list of documentation that you need to be able to answer in those online questions, because if you don't have it right in front of you, it'll time out and you have to start all over again answering the questions. So that's not any fun. So Social Security disability income, SSDI, comes along with Medicare after 2 years, and hopefully you've got your health insurance taken care of then. But SSI, because the rules, the asset eligibility and the income eligibility are pretty much identical to Medicaid for health insurance, you can qualify for disability Medicaid immediately upon getting SSI eligibility. They kind of go hand in hand. Ohio Medicaid is supposed to now, under the newest rules, if it comes through the system that you have SSI, then you automatically get Medicaid attached to it. Sometimes you have to bring that SSI determination to Medicaid to say, hey, look, I've got SSI, I need to have this Medicaid now because I didn't work, I don't have health insurance, I don't have money to pay for it, so I need this disability Medicaid. With SSI, that disability Medicaid comes with not just health insurance, but it comes with oftentimes care managers, food stamps, subsidized housing, a lot of extra nice things that somebody on SSI would probably need. Now, looking at the Medicaid rules, you see the asset eligibility is $2,000, and it's if a child is disabled under 18, their parents' assets are deemed to them, which is why a lot of people at 18, that's when the application is made. For income eligibility, again, there's deeming of the parent's income to the child under 18, so oftentimes that SSI application has to be put off till age 18. Very similar exempt assets, a house, a car, a funeral, cemetery plots, your stuff. Yeah, they always let you keep your stuff. Now for Medicaid though, for disability Medicaid, there are a little bit different gifting, transfer, punishment rules, where Social Security has a 3-year look back. Medicaid for disability has a 5-year look back. So if you've given away money to qualify for SSI and you waited 3 years before applying for SSI, for the corresponding Medicaid, you might still not be eligible, even though you're asset and income eligible. If you've given away any money within 5 years of that application, then that's a problem for Medicaid. So you might need to just not push the Medicaid if there's still a penalty period sitting out there, even though you're past the 3-year look back for Social Security disability. For Medicaid, let's say that same $50,000 gift was made, and it was made within 5 years of you're trying to get the Medicaid, and the gift was within 5 years of that Medicaid part. They will look back, see that $50,000 gift. Now the calculation for how many months is a lot different. For SSI, it's the amount divided by the maximum monthly SSI benefit you can get. For Medicaid, what they do is, whether you're getting disability Medicaid at home, in an assisted living, in a nursing home, in a group home, the calculation of the number of months of ineligibility are pretty much the same. You take the $50,000 gift that you made within that 5-year period, divide it by the average cost for 1 month in the nursing home. In the state of Ohio, they average all the months, cost per month at all the nursing homes. Average it together, it's currently $6,905. That is not the amount that most nursing homes charge in the Cleveland area. We're talking in the Cleveland and Northeast Ohio area, it's probably more like $8,000 to even $13,000 I'm seeing in some cases, where somebody who's really not doing well and needs that nursing home care. So they take the $50,000 gift you made, divided by $6,905, the average cost for 1 month in the nursing home for the whole state of Ohio, and it ends up being about a 7-month penalty period for Medicaid. So a gift for getting Social Security disability, for the first 3 years that's a problem, then it goes away. For Medicaid, it's a 5-year look back. If the amount that you're gifting is pretty small and you wait 3 years for Social Security for the SSI benefit, for Medicaid, it might end up being a very short period of time of waiting for the Medicaid health insurance that covers the care management and food stamps and subsidized housing and all that stuff that comes along with it. The penalty might be really short, and it might be worth it not to have to wait a full 5 years. But the rules are complex, and you have to make sure you're meshing with what Social Security is looking for, with what Medicaid is looking for, and you don't apply too early nor too late to get the benefits that you need at just the right time. So there is this interplay between the two programs, and you want to make sure you get the best of all the worlds that you possibly can. Again. Okay, so we know that there's these programs out there to try to get some extra income on a monthly basis to help you live, to help care of your health expenses, to help get you somebody maybe in the home to take care of things. And sometimes you have to worry about having too much money. If the child or the disabled individual comes into money, that's a problem for the SSI portion, maybe not for Social Security disability income. And if you want to leave assets for the benefit of your child, whether they're minor or an adult at the time, you got to follow certain rules to be able to have those benefits not count against that disabled person's Social Security benefits and Medicaid benefits. So we're going to spend some time talking about ways to plan to obtain benefits and protect assets during that disabled person's lifetime. Okay, so first, let's talk about the child's money. This could be, like I said before, something that they got as a gift, a car accident, a medical malpractice claim, all kinds of things that could cause that disabled person to get some money in their hands. So we talked about gifting already. We just finished talking about that. Gifting is not necessarily a good idea because it can cause a penalty period during which SSI will not be available, and it's really necessary. So be really careful with gifting. There is something called a stable account at the end of the list here. I'm going to talk about that in a few minutes. That could help if there's just a little bit of money over the excess, over the $2,000 limit, and you're just trying to get rid of it. The stable account might be something to think about. We're going to get there. So we're not going to just willy-nilly give away money. That would cause penalty periods. So there are ways to put that money away for that disabled person, even though it's their own money. There are certain types of trusts and accounts that can be set up. So let's first talk about the first thing on the list. There is the first party special needs trust. Okay, first party in this context means it is the disabled person or child's money. It's money they have in their own account, in their own name, that will disqualify them from getting benefits to begin with, or make them lose their benefits if they're already on. So a first party special needs trust is a special kind of trust agreement. This is a custom drafted, like you'd go to the attorney's office and have this kind of trust set up. So first party means it's the disabled person's money. This special kind of trust for that kind of money can be set up by the beneficiary if they're mentally able. It can be set up by a parent, a grandparent, a guardian, or the court. So there's a lot of ways this can be set up for that person, even if they can't do it themselves. So the first party is that it's the disabled child and it's their money. The trust is set up. The disabled person cannot be in charge of the money in the trust. The person in charge of the money is called the trustee. The trustee has to be somebody else. And one nice thing about having a first party special needs trust drafted by an attorney, it can be a family member who understands the needs of that disabled person and has a special feel for what's good and what's bad to spend money on. The trustee's in charge of the money and investing it. What bank accounts, what investments, whatever. And then the trustee has the ability to take money out of the trust in the trustee's complete discretion. There can't be rules in the trust that says the trustee has to give the money to this person if they need help with health expenses. The trustee can give this money to the person if they need help for rent, those kinds of things. It's completely discretionary. That's the only way it works in Ohio. The trustee has the right to distribute some, all, or nothing of the trust to the disabled individual or for their benefit. It's completely discretionary for almost anything, except it cannot be used for food and shelter, which is sort of room and board. Under the SSI rules, if a trust is paying for a disabled person's room and board, it can be at home, in an apartment, in a group home, whatever it is, then the SSI check is cut by a third because Social Security says, well, you don't need that much money every month because somebody else is paying for these particular expenses. So there is a prohibition in the trust from the trustee using any of the money for food and shelter. That's groceries, rent, mortgage, utilities, things like that. they're supposed to be getting SSI and then subsidized housing and food stamps through the Medicaid program to pay for all of those things, and the trust isn't supposed to pay for them, otherwise they lose some of their SSI. Now there's other ways around that. Remember that stable account I mentioned before? It's at the bottom of the list. We're going to talk more about that there. So when this person who had their own money put into the special needs trust, when they die, Medicaid has a special right to be reimbursed. The state of Ohio Medicaid program is reimbursed out of that trust. It's Medicaid payback up to the amount that Medicaid paid on their benefit. Medicaid has that, it's in the rules, that's the right, because they let you keep money in this first party trust when if you kept it yourself, you would have been disqualified. However, you put it in this trust, Medicaid goes, okay, we'll pay your benefits all the way through your lifetime, but when you die, we want to get repaid for those benefits that we let you have. So it is Medicaid payback. Anytime it's the disabled person's money that goes into one of these trusts, it can be used for their lifetime for almost anything except food and shelter, and then at their death, before anybody else in the family gets anything, it is Medicaid payback. That kind of trust is mostly, like I said, custom drafted, and an attorney sets it up. Makes a lot of sense when there's a lot of money and there's family members who are able and willing to help out the disabled child or person. There's also something called a pooled income trust, the next thing there on the list. A pooled income trust is the same idea, except it's set up and maintained by a nonprofit organization to help beneficiaries who get money coming in and they have to get rid of it to apply or retain benefits. In our area, it's Community Fund Management Foundation, or CFMF. Their website is cfmf.org if you want more information about them. So around here, that's where we go to for one of these pooled income trusts. They have set up they call it a master trust. People in the community, all these beneficiaries can join into it, and they keep their own little share of the pot. It's all calculated on paper, but they pool everybody's assets to invest it, so everybody gets a better interest rate on the earning. The earnings are better when you're pooling $100,000 than when you're pooling $10,000. So everybody gets a little bit more income. The Community Fund Management Foundation is the trust advisor. They help set up the trust, and you have to join into this thing. Plus, there's a fee to join into it. It's typically much less expensive to join into the pooled income trust than it would be to set up a first-party special needs trust. But so if you have a lot less money, usually I'll direct people to the pooled income trust. Even though it's set up and maintained by this nonprofit organization, CFMF, an attorney has to sign off on the paperwork, has to prepare the paperwork, go through it with the disabled person and their family before CFMF will accept that application to join in. They're not attorneys, and they can't tell you all of the ins and outs of the rules and make sure that it's the right choice for you. So an attorney has to sign off on it anyway, because these rules are very complicated. So the trustee of that trust, one reason that you might not like it as much as a first-party special needs custom trust is that the trustee is Huntington Bank. So it's a third-party committee rule. They don't care what your loved one's disabilities are. They decide whether or not it's appropriate to make a distribution. They can make a distribution in their discretion for anything except the food and shelter, the room and board. But they're going to probably be much more conservative investments, and they're going to be much more careful of distributing assets because they have a higher level of fiduciary duty. They're held to because they're professionals, as opposed to a brother or sister or uncle or aunt who's handling the custom drafted trust. So it takes longer to get the money out. They're very impersonal, but there is a place for that type of trust anyway. It's an option. So now looking at those two trusts, let me jump to the stable account for a minute. The trusts, whether they're custom drafted or part of CFMF, are not allowed to make distributions for the beneficiary's room and board. However, a stable account can make those kind of distributions. So the federal government came up with this ABLE account. It's an account for a disabled person. It lets you keep a little bit more personal money, access it with usually a debit card. One card is called TrueLink. In Ohio, they call it a stable account because it's supposed to help people have stability in their life if they're disabled. And the stable account works with the TrueLink kind of debit card so that if possible, the beneficiary of that money can access and buy their own things. The stable account can only be set up if the person for whom it's being set up by themselves or a family member was disabled under the age of 26. If they're disabled because of a car accident at 52, you can't set up a stable account for that. But if it works, the first party special needs trust, the custom drafted one, and the pooled income trust through CFMF are allowed to make distributions to the stable account, and the stable account is allowed to pay for room and board for that disabled person. There's some limitations on how much you can have in the stable account. You can't put in more than $15,000 a year. And that doesn't mean $15,000 from mom and $15,000 from dad and $15,000 from grandparents. It means a total with all of the money being deposited, a total of $15,000. There's a little bit more that can be put in if the beneficiary is actually working. You can add some of those earnings into that. It can't go over $100,000 in total because it can blow the Medicaid at that point. But it's a way for a beneficiary to have their own account, even if a parent is managing it for them, and be able to pay room and board if necessary. Now, just like the first party special needs trust and the pooled income trust, the stable account, this is money that Medicaid is saying, okay, we'll continue your benefits while you put that money away into that trust or that account. But when you die, it's Medicaid payback. So you don't necessarily want a huge balance in a stable account because at death, it could all go back to the state of Ohio rather than going to other members of the family. Then, skipping back up the couple, apply for any possible benefits, get in with the DD board, get help from an attorney who works with disabled individuals. There's also that website, www.benefitscheckup.org. I found that very helpful for my clients. You go to that website, it asks you some various information about where you live and what you're looking for, but it can come up with benefit programs, federally, state, county, city, local, community benefits that I couldn't possibly keep in my head if I tried because they're changing all the time. And different parts of Ohio have different provisions for benefits for disabled folks. So it's a great place to look for benefits and apply for everything. Apply for everything that you can and help that disabled individual get the best life possible. And push it. If you don't get through and get approved for something, just like for Social Security benefits, it usually takes 2 or 3 rounds of being denied before you finally get approval. And after the initial application, which usually people make on their own for Social Security, then you can hire an attorney to take it up on appeal. But you got to push to get the benefits. They're not going to give them to you probably willingly. So if the child has money, there's one branch of types of planning that we do. What if it is the parent's money or somebody else's money that they're trying to protect and have a pot available for their disabled child or grandchild or whatever for the future? So what some people do, thinking about estate planning when they die, is I'll just give the money to my other children, and I know that they're going to take care of their special needs sister. Money makes people go insane, and sometimes that will help or work, and sometimes it won't work. So you have to be careful with that. Also, the problem with leaving the money for your other children, in addition to them potentially not helping their sibling and spending the money, if they get sued, then that money you kind of earmarked for your disabled child ends up going to the lawsuit, the creditors of that other sibling, If they get divorced, the money might have to be split. If the child who's holding money for their disabled sibling dies, we don't know where that money is going to go. So it is one way, and some folks that I work with just insist upon doing that. I don't know that it's the best possibility for protecting assets. So better to go into a trust plan. So we talked about first party special needs trusts. The corresponding kind of trust, when a parent or somebody else is trying to set up money to be held in trust in a special needs trust for a disabled beneficiary, is a third party special needs trust. What that means is it's not the beneficiary, it's not the disabled person's money. It's mom and dad's money or grandpa's money. A third person is funding this trust for the benefit of this disabled individual. When it's a third party special needs trust, it's not the beneficiary's money. It is the parent's money, or whoever set it up, money for that person. So it runs just like the other special needs trusts I've already talked about. The trustee, who cannot be the disabled individual, the trustee holds the money and invests it for the benefit of that disabled individual, and has complete discretion to make distributions or purchases or not make them for anything except for food and shelter. So the food and shelter part can be handled by a stable account if that's appropriate under the circumstances. Another way to deal with room and board in any of these kind of trusts is if the child is getting SSI and the parents want to provide a home for that child after they're gone, keep that child in the home that they've been in their entire life and bring caregivers in, and maybe that child was not disabled until after age 26, so they can't set up a stable account to pay for mortgage and utilities and things. The way that they can keep the SSI, the entire SSI check, and still pay for those expenses is having the child, through a guardian or themselves, if they're okay to do so, set up a lease agreement with the trust. So the trust is renting them the house, and maybe make it a room and board agreement, so the trust is paying for groceries and paying for the home, and the beneficiary, to keep their whole $783 check each month and not lose a third of it because Social Security says, well, the trust is paying for it, we don't have to give you as much. If there's a rental agreement between the beneficiary and the trustee of the trust, then maybe the beneficiary pays the trustee a couple $100 a month for room and board. They will continue to get their full Social Security check, SSI check, because they have a rental, they're paying for room and board themselves. But then the trust takes that money, turns around and keeps it in the pot for the benefit of the disabled child later on. So it's a way to get around the room and board rules of trusts if you can't have a stable account. So the third party special needs trust that is set up by an attorney is very personal. You've got a trustee who knows the family and knows what's going on. And then, but what if you don't have quite as much money? You don't want to spend the money to set up a third party special needs trust, or it's a smaller amount. Community Fund Management Foundation has a different version of the pooled income trust called a master trust that is designed to be set up by parents or others for the benefit of a disabled individual. So it's somebody else's money being held for the benefit of the disabled person. Same rules like any of these other special needs trusts. The trustee involved has to invest the money, can make distributions to the person, or preferably to buy things for the person, for anything in their sole discretion except for food and shelter. And at the end, because this is a third-party trust set up by somebody else's money, the trust allows it to be distributed to other family members at the death of the disabled individual. There's no Medicaid payback for third-party trust because the money never became the beneficiaries like the first-party type of trust. It was always somebody else's money being held for the benefit of that individual. So with planning for the future and your money for your child or grandchild or whatever it is, you're looking at a whole different set of types of documents. You got to be sure that the right money goes into the right kind of trust. If you put third-party money, your own money, into your child's first-party special needs trust, it suddenly becomes Medicaid payback. If a beneficiary, who is the disabled person, tries to put money into their parents' third-party special needs trust, it taints it and makes even the third-party trust, which would not be Medicaid payback ordinarily, money from the beneficiary going in there makes it a first-party special needs trust subject to Medicaid payback. So it's not simple to jive all of these rules between Social Security and different types of Social Security and Medicaid, and there's different types of Medicaid even, and then there's these trusts. Which kind of trust is the right thing? There has to be special language for a first-party special needs trust in Ohio. It's different than language that has to be in a third-party special needs trust in Ohio. So there's a lot to think about when you're dealing with how to protect assets for the future. So how can I protect my child or grandchild or whoever it is that you're worried about who is disabled? Come to seminars like this, seek and question information. There is so much information out there. And as we all know, hopefully by this point, the internet is not always accurate. So you really need to find somebody who knows what's going on with all of this and ask questions. If you have a child in the DD system going through school and you're worrying about individual education plans, IEPs, and all the kinds of things, it's overwhelming sometimes if you have a child born with a disability or something happens early on. You've got to just keep pushing to get the information, and don't put off having proper estate planning documents in place for yourself. I have a lot of people who don't ever get to doing any of that until the child is grown up, maybe over 18, now in place on SSI and getting Medicaid, and the parents go, phew, now I got to think about what are we going to do when I die. So don't wait that long. Everybody needs a will and a financial power of attorney and a healthcare power of attorney and a living will. Everybody needs that. And if you have a special needs child or somebody in your life that you're trying to make sure is okay, you need a trust agreement. There's really no other good ways to set up that money without setting up a trust agreement, whether it's privately drafted by an attorney or whether it's through the Community Fund Management Foundation. Either one is available. They have their pros and cons, and you have to decide what's the best. If you have a child who is now 18 and is able to sign their own estate planning documents, you're not going to be able to take care of them as a parent and legal guardian for their whole lifetime. If they're mentally okay to understand and sign estate planning documents, maybe they don't need a will because they don't have any money, but they certainly need a financial power of attorney to do banking for them, a healthcare power of attorney to make medical decisions, and the living will. I mean, those are documents everybody should have. If your child is turning 18 and is really disabled so that they can't make any decisions on their own, some parents go to court and become a guardian, and some don't. It depends upon what you have to be doing. Either way can work. It just depends upon the situation. So that's something to think about and get advice about. I already said this, apply for all benefits available. Always try to get every kind of help. Avail yourself of everything you can. I had one client who was an adult, had just awful allergies, and she tried for 10 years to get Social Security benefits, and she finally became the Social Security disability that she was able to qualify for. It's not easy. It's not necessarily do it yourself. You might need the help of agencies or attorneys and other professionals who can help you navigate the minefields and get the right kind of planning in place. I also say hire a qualified disability law attorney. disability law can be getting Social Security, it can be getting Medicaid, it can be getting Medicare, it's all kinds of different things. And I'm an elder law attorney and certified in that, but elder law includes the disability side of things too. It's very similar when you're getting older and unable to make decisions as to when you're disabled and unable to make decisions and care for yourself. So get somebody who's got that kind of background and can explain things and can pick the right path that you need to go down. Of course, I would be happy to help you in that. However, even if you hated my presentation and don't want to see me ever again, get to talk to somebody so that you can make the right choices in life and for yourself and for your disabled child or other individual that you're trying to help out with their life and during your life and when you're gone. So I don't think anybody asked me any questions on the chat screen. So does that mean this was perfect and you all understand everything? If you have a question, you can put it in that little chat box and it'll come to me and I can answer it. Okay, don't jump all at once. If not, that's okay too. As I said, we are going to be sending out a copy of these slides and a little bit more detailed outline to everybody who attended and those who signed up, and there's a few I see couldn't make it at the last minute, so we're going to send out that information to them as well. If you want to contact us for some help, please do that. Again, here's my contact information. Thanks for Zooming with us. If you need help, please let us know. This is what we're here for. Or see somebody. Just do something about it. Don't just let it go where you know, let it go to chance. Chance is not the best option for most people. So I appreciate, oh, stable account. Can you open this at any bank? Oh, good question. There's actually, it's not, you don't open those on at a bank. You go to the website and you can search for stable accounts in Ohio, and you actually set up those accounts online. They're just online banks. So everything, you make deposits with credit cards or other ways to make money in. You get the TrueLink card, and that's how you can take money out, or you can request money from the account to be distributed out in the form of a check. But you set those up online. Just search, as I said, for stable accounts. Any other questions before we're all, oh, do we have a Westlake office? We actually do. We have the main office in Mayfield Heights, which is on my screen. And I have no idea what those little green things are. Oh, made everything go away. Let me stop sharing and share again. Get over here and put the screen back up. Click to the end. Whoops, there we go. So we have the Mayfield Heights office, which is our main office. We have a satellite office on Rockside Road in Independence, and we have a satellite office also in Westlake near Crocker Park. The satellite offices are not manned every day. If you wanted to meet at one of those offices, then you call the main office and we reserve time to meet over there. So, but this is my contact information. I feel free to email me later if you have any questions that you didn't want to say or didn't think of right now. And this tape is taped, so it will be on YouTube at some point for you to read and view later. Otherwise, I will let you go with your evening. It's just about 7, so I will let you all go. Oh, thanks for the great presentation. Well, thank you to those who thanked me for having a presentation that you thought was great. I like to hear that. It makes me keep going on more presentations. The next one, by the way, the next presentation our firm is putting on is August 22nd. That's a Saturday. It'll be a Zoom like this between 2 and 3 o'clock. Probate avoidance is the topic of that one. So you can look for emails or you can call the office to reserve that spot, and hopefully you'll be able to learn something about probate avoidance too. So Anything else anybody's got? Last call. I think I can stop sharing, and then I can hit the end button. Are we good? Everybody done? Uh-oh. Thank you so much. I will make an appointment with you tomorrow. Well, hey, thank you so much. I am going to end it now for everybody. Have a good evening. Sleep tight and stay safe and healthy. This has been a terrible time in our country recently. Bye-bye.